We are very honored that today's thought-provoking discussion on voting rights could include a featured address by a member of the Obama administration who grapples with these issues every single day, Assistant Attorney General for Civil Rights, Tom Perez. Tom has spent his entire career in public service. He was nominated by President Obama to serve as Assistant Attorney General and was sworn in on October 8th of 2009. Prior to serving in the Justice Department, he served as the Secretary of Maryland's Department of Labor, Licensing, and Regulation, which protects consumers through enforcement of a wide range of consumer rights laws. And from 2002 to 2006, Tom served, and I have to say, as a constituent, very capably, on the Montgomery County Council and served as council president in 2005. Earlier in his career, Tom spent 12 years in federal public service, most of those years as a career attorney with the Civil Rights Division. During that time, he prosecuted and supervised the prosecution of some of the department's most high-profile civil rights cases. Tom later served as Deputy Assistant Attorney General for Civil Rights under Attorney General Janet Reno. He also served as special counsel to the late Senator Edward Kennedy and served as his principal advisor on civil rights, criminal justice, and constitutional issues. For the final 2 years of the Clinton administration, Tom served as the director of the Office for Civil Rights at HHS. Obviously, Tom has a great deal of experience and insight, even apart from him having the job most on point for today's discussion. So I am very pleased, on behalf of ACS, to welcome Tom and to thank you for coming to speak to us today.
Good afternoon. Caroline, thank you for your kind introduction. It's always a pleasure to see you, and it's always a pleasure to know that I don't have to make sure that I'm keeping your streets plowed anymore. So that's a good thing. It's great to be back here at CAP as well. It's great to see all the familiar faces, and I'm happy to join you here to talk about the division's work to protect the fundamental civil right that is really the lifeblood of our democracy, which is the right to vote. You know, on July the 2nd, 1964, President Johnson signed the Voting Rights Act. The act expanded opportunities, as you know, across a wide swath of areas that cover American life, from public accommodation to housing to employment to education. It was one of the most important pieces of legislation in the United States history. I remember seeing it on the wall of Senator Kennedy's office when I used to go and brief him on things. And yet, despite that wide breadth of that law, we all knew that considerable unfinished business remained. And the leaders at that time knew that it was no time to rest on their laurels. In fact, 4 days after the bill was signed, a young leader named John Lewis led a group of African Americans to a county registrar in Alabama where they sought to register to vote. The sheriff, rather than allow them to do that, arrested them. We all know who John Lewis is. We all know that civil rights is about persistence, and Congressman Lewis was one persistent leader. He did not give up. A few months later, as you know, the Selma voting rights movement began. On the first Sunday in March of 1965, a day that would live in infamy as Bloody Sunday, John Lewis and others confronted the blatant bigotry and brutality of people who did not allow them to cross that bridge. Bull Connor-like law enforcement officers, and as they tried to march across the Edmund Pettus Bridge, seeking the voting rights of African Americans, we all know what happened. 10 days after Bloody Sunday, President Johnson introduced the Voting Rights Act. And less than 5 months later, that bill became law. I was looking at it the other day. It was interesting to note the vote count for the conference report. 328 to 74 in the House, 79 to 18 in the Senate. In marking the bill's passage, President Johnson made clear the dramatic impact of the law when he said, "The vote is the most powerful instrument ever devised by humankind for breaking down injustice and destroying the terrible walls which imprison men and women because they are different from other men and women. 41 years later, Congress once again came together in an overwhelmingly bipartisan fashion to reauthorize the Voting Rights Act. Congressman Jim Sensenbrenner, a Republican from Wisconsin who was then, as you know, the chair of the House Judiciary Committee, noted that the reauthorization was based on, quote, one of the most extensive considerations of any piece of legislation that the United States Congress has dealt with in the 27.5 years that I have been honored to serve as a member of this body. By a vote of 390 to 33 in the House and 98 to 0 in the Senate, Congress determined that Section 5 of the Voting Rights Act, a linchpin of the law since its inception, was still necessary to prevent minorities from being, quote, deprived of the opportunity to exercise their right to vote or having their votes diluted, undermining the significant gains made by minorities in the last 40 years, unquote. A few months ago, a federal district court rejected a constitutional challenge to Section 5 of the Voting Rights Act, and he correctly noted that Congress determined in 2006 that 40 years has not been a sufficient amount of time to eliminate the vestiges of discrimination following nearly 100 years of disregard for the dictates of the 15th Amendment. President Johnson was right. Congressman Lewis was right. Congressman Sensenbrenner was right. Judicial decisions spanning over a century have identified the right to vote as, quote, preservative of all rights, a conclusion that is as true today as when the Supreme Court first made that pronouncement in 1888. Now, why do I provide this history? I do so because it's important to remind ourselves that voting rights, and indeed civil rights, has a proud bipartisan tradition in America. From the Voting Rights Act of 1965, the Civil Rights Act of 1964, the Fair Housing Act of 1968, the Americans with Disabilities Act of 1990, the reauthorization of the Voting Rights Act multiple times, the Matthew Shepard, James Byrd Jr. Hate Crimes Prevention Act of 2009, all of these are a byproduct of bipartisan coalition building. You know, I also reflect on this history to remind myself and our staff of the solemn responsibility that we have to enforce voting rights and other laws that so many people fought for and regrettably in many cases died for. That is very important, and that's why the Attorney General has often referred to the Civil Rights Division as a crown jewel of the Department of Justice. The laws that we enforce are in fact the crown jewels that ensure access to opportunity and equal access to participation in our democracy. When I first became AAG for Civil Rights more than 2 years ago, I pledged to restore and transform the division and to vigorously enforce all of the laws under our jurisdiction. Since the beginning of their tenure, President Obama and Attorney General Holder have repeatedly made clear their commitment to robust civil rights enforcement that is vigorous, fair, and even-handed. This is a commitment that my colleagues and I in the division share, and we take very, very seriously. And it is nowhere more important than in the voting rights context. I had the privilege, as I said, to work for Senator Kennedy, who often said that civil rights is the unfinished business of America. And it is regrettably true that unlawful discrimination in voting persists, just as it does in the workplace, in schools, and so many other parts of our lives. And this is why our voting section is as busy as it's ever been. We handled 27 new cases during the last fiscal year, and that doesn't include all the ongoing cases that were opened in previous years. Based on our review of our historical docket, we believe that this number exceeds the number for every single year going back to 1977, which is the earliest year for which we could construct the records. I believe there may have been one year where we had a tie in terms of the number of cases, but we're as busy as ever. And our enforcement approach is rooted in 3 core objectives. One is a process objective, while the other 2 are substantive objectives. On the process front, we have recommitted ourselves to ensuring the integrity and independence of our decision-making processes. Substantively, we are pursuing an enforcement program that seeks to ensure access to democratic participation for all legally qualified voters and ensures equal opportunity to participate in the democratic process free from discrimination. Access and non-discrimination. Those are 2 words you will hear a lot from me today. And as I'll describe, we are taking a multifaceted approach to the issues of access and non-discrimination. And it includes a comprehensive effort to enforce Section 5, to enforce the NVRA, to enforce the language minority provisions of the Voting Rights Act. Section 2 of the Voting Rights Act, UACAVA and the MOVE Act, which protect the rights of members of the armed forces and other civilians who are living overseas. This comprehensive approach toward these and other critical voting rights protections involves not simply litigation, but other tools that are at our disposal, including guidance, education, outreach, and all of the work that my colleagues have done. In order to carry out the substantive enforcement, it is imperative to ensure that we have investigative and decision-making processes and protocols in place that are unimpeachably fair, independent, and even-handed. And I want to talk about these process issues because, regrettably, Attorney General Holder inherited a Civil Rights Division whose long-standing commitment to even-handed, independent enforcement to civil rights laws, including voting rights laws, had been compromised. The politicized hiring of the prior administration, which is well documented in a 2008 report, had a dramatic negative impact on the Civil Rights Division. Under the leadership of Attorney General Holder, we have worked tirelessly to restore fair and even-handed hiring processes in the Civil Rights Division and to ensure that decision-making in every case is governed by a careful and impartial application of the facts to the law. Let me give you an example of how decision-making processes were compromised and what we did to fix it. As you know, Section 5 of the Voting Rights Act is one of the critical tools to combat discrimination in voting. Section 5 was put in place because of the well-documented history of government-sponsored discrimination in a number of states. And it currently applies to all or parts of 16 states. These jurisdictions are required, as you probably know, to obtain pre-clearance for every change that they make to their voting procedures and practices, and to demonstrate both that the change had no discriminatory purpose and that it has no retrogressive or discriminatory effect. Changes ranging from moving a polling location to a different place to the enactment of a statewide redistricting plan must be pre-cleared in order to go into effect. A jurisdiction can obtain pre-clearance either by filing administratively with the Civil Rights Division or by filing a suit in front of a 3-judge panel in the District of Columbia. Under either scenario, the Civil Rights Division is intimately involved. If this jurisdiction chooses the administrative route, and I'll note that most jurisdictions take this route because it's faster and less expensive, then the division acts as a quasi-judicial body in reviewing this submission. In these circumstances, if the department determines that the jurisdiction has met its burden, then the proposed change is pre-cleared. Or to put it slightly differently, once the department determines that a plan should be pre-cleared, nobody can appeal this finding. The Section 5 case is over. Now, this doesn't prevent other actions under the Constitution or other provisions of the Voting Rights Act, such as Section 2, or applicable provisions, if any, of state laws and state constitutions. And why am I telling you about this? I'm outlining this because the division, in carrying out its Section 5 responsibilities, has substantial authority. We act, as I said, in a quasi-judicial capacity. And with this authority comes a corresponding responsibility to ensure that the decision-making process is fair, thorough, and independent. The dedicated and experienced career professionals play a critical role in ensuring the integrity of the review process. A guiding principle in our Section 5 review is to give every person who's working on the submission the opportunity to express his or her views, because I truly believe that a robust and honest exchange of ideas is critical to effective decision-making. This had been the long-standing tradition in the voting section in both Republican and Democratic administrations for decades, until it was changed in 2005 to exclude career attorneys and analysts from full participation. Career staff, for instance, were directed to no longer put their recommendations in writing. And if you don't have the recommendations in writing, it becomes much easier to create a false impression of consensus when in fact consensus is not the case in a particular submission. So decision-making suffered, and potentially flawed decisions to pre-clear submissions, as I said, are non-reviewable. These changes were wrong. They shouldn't have happened. We enforce the Voting Rights Act. We don't enforce the Republican Party Empowerment Act or the Democratic Party Empowerment Act, and we do a profound disservice to the nation and to the bipartisan group of lawmakers that overwhelmingly passed the Voting Rights Act and reauthorized it multiple times when the Voting Rights Act is allowed to be subverted for partisan purposes. Now, it has been suggested that one possible approach to address any imbalance in past enforcement is to undertake imbalanced enforcement of our own. The Attorney General and I categorically reject that approach. Two wrongs don't make a right. I learned that when I was 5 years old. In addition to restoring career-driven, merit-based hiring, we have restored the integrity of the decision-making process in Section 5 and all voting rights cases, and in fact all the work we do across the division. As a result, our decision-making has been considerably strengthened. Now, a consequence to this approach, and it's a consequence that we readily accept, is that there have been times and will continue to be occasions during our enforcement efforts when we have disappointed and will disappoint people across the entire ideological spectrum. This is true in all of the areas of our work, and our voting work is no exception. So while I can't commit that we will always agree on the right outcome in a given case, and I suspect we will continue to have areas of agreement and disagreement, no matter where you sit across an ideological spectrum, it is precisely because there will frequently be someone who would prefer a different outcome on the merits that the department must have your confidence that our decision-making process is fair. That is critically important, and that is why I have spent so much time this morning talking about our process. Now, an ounce of prevention and outreach is worth a pound of cure. And in the redistricting context, we have invested considerable time and energy explaining the Section 5 process to lawmakers and other key stakeholders. We have revised and published our Section 5 guidance, traveled across the country to conferences, met with elected officials in a nonpartisan fashion in an effort to get the word out that a good, legally defensible result in the redistricting context begins with an inclusive and transparent process. So, for instance, I traveled to Louisiana at the invitation of the Republican and Democratic leadership, and I addressed a bicameral session of the State House of Representatives and the State Senate on Section 5 issues. I outlined the process. I addressed a number of questions from members in an open session that had never before been conducted by an Assistant Attorney General. I'm very proud that we have restored the independence and fairness of our process, and I have 100% confidence in the career staff that is doing our Section 5 work. And we wanted to make sure in our outreach that elected officials have processes that are indeed transparent and fair. Now let me turn to our substantive work that we've done. Let me get back to the issues of access and non-discrimination. And let me stay on the topic of Section 5, because Section 5 is indeed one of the linchpins of the Voting Rights Act. There are some who challenge Section 5 and they contend that it's no longer necessary, and they also contend that it's over-inclusive because there are jurisdictions whose record of reform merits removal from Section 5 coverage. I think our ongoing work in Section 5 is the best demonstration that Section 5 is constitutional and it remains critically necessary. For those who believe that the country has eradicated voting discrimination in the 46 years since the enactment of Section 5 and that therefore Section 5 is no longer needed, I would submit that our voting rights docket is proof positive that this is not the case. I would submit that you just need to spend the last couple months with us to see that point, because since October, the department has objected to 5 different voting changes across the country on the grounds that these changes were discriminatory. In Texas, for instance, where the state asked the federal court to review their redistricting plans, we have lodged our objections in our court filings that the proposed maps for both the State House and the Texas delegation to the United States Congress are impermissible because the state has failed to show that they are neither intentionally discriminatory nor lack a retrogressive effect. With regard to the congressional map, for instance, Texas was allocated, as you probably know, 4 new congressional seats because of population growth. And although the majority of that growth was spawned by an increase in the Latino population, the state proposed adding 0 additional seats as Hispanic ability to elect districts. The state, in the context of redrawing the State House of Representatives districts, used an unusual process to make changes to the districts at a level in which only racial data was available. This raised questions about the state's ability to show that the plan met Section 5 standards. While the litigation is ongoing, and so I can't comment much further, I will note that a 3-judge court in D.C. recently gave an important interim victory when it held that, quote, the state of Texas used an improper standard or methodology to determine which districts afford minority voters the ability to elect their preferred candidates of choice, unquote. The department has also objected to recently enacted redistricting plans in East Feliciana Parish, Louisiana, Meade County, Mississippi, as well as refusing to change an earlier determination that a change in the method of electing city council members in the city of Galveston, Texas, violated Section 5. We analyzed redistricting plans for local government positions with the same rigor and independence as we employ for statewide plans. In addition, it would be incomplete to measure the impact of Section 5 simply by looking at the number of objections. Section 5 also fulfills a critically important prophylactic function, wholly apart from discriminatory practices we identify and object to in the course of our review. Because covered jurisdictions know that their voting changes will be reviewed under Section 5, most jurisdictions are particularly careful to avoid discriminatory practices. For this reason, Section 5 has instilled an ethic of inclusion and opportunity that can't be captured simply by looking at the number of overt discriminatory practices it bars after they've been enacted. I have heard time and time again in the course of my outreach from state and local legislators, that the existence of Section 5 keeps the process honest. Those are the terms I've heard multiple times. And it prevents backsliding that would otherwise occur. In the redistricting context, for instance, most state and local governments are aware of the need to prevent retrogression, and they often actually begin their process by identifying districts that ought to be protected in order to address Section 5 issues. Now, I hope all of the examples make clear that Section 5 continues to play a vital role in upholding equality by stopping discriminatory voting practices from going into effect, whether they are statewide, countywide, city level. And I would note that to those who believe that Section 5 is over-inclusive, this concern is disproved by the ability of jurisdictions with a clean record of non-discrimination in voting to bail out of Section 5 coverage. Following the Supreme Court's recent decision in the Northwest Austin case, the department has handled a record number of bailout actions. And where, at the end of our independent review, a jurisdiction meets the bailout standard, we have not hesitated to reach consent decrees that allow bailout. Overall, since January of 2009, the district court in D.C. has granted bailout in 12 cases. These include the first ever cases from covered jurisdictions in Texas, Georgia, and California, the first bailout from North Carolina since the 60s, and a number of additional bailouts in Virginia. That's very important as we move forward to demonstrate that the law is both necessary and is not over-inclusive. So, I've talked about Section 5, and I also want to talk about one more issue, because I know it's an issue that is very, very much in the forefront of your discussions. We are looking at a number of inquiries regarding state laws relating to voter identification requirements, voter registration requirements, and changes to early voting procedures. We have a number of tools in our toolbox to take a look at these issues, and a number of these laws have been passed in states that are covered by Section 5. So for instance, Texas and South Carolina have enacted laws regarding photo identification requirements, and we are currently reviewing these submissions. And in both cases, our initial view was that the states did not submit enough information to allow us to determine whether they had met their burden. And so we requested more information from both states, and our review remains ongoing. Florida has also implemented a number of changes to its electoral process, including changes to the procedures governing third-party voter registration organizations, as well as changes to the early voting procedures, including the number of days in the early voting period. Now, they originally submitted it for administrative review, which meant that the 60-day clock began to run. In the course of that review, we asked a number of questions, and on the 50th day of that review, they withdrew the submission. And they filed a lawsuit for judicial review of 4 of these changes. That is their right, and while I can't go into detail on review of any of these cases, I can assure you this: our review will be thorough, it will be independent, and it will be fair, and it will be fact-based. And remember, these states bear the burden of showing that the proposed changes are not intentionally discriminatory and will not have a retrogressive effect. And if they meet that burden, we will pre-clear the changes. If they don't, we will object. Now, another critical part of the docket that's reflected in the Florida lawsuit and a number of others is our work to defend the constitutionality of Section 5. There are a number of cases in this context, and we continue to be firmly committed to vigorously defending Section 5's constitutionality. And although the litigation is far from over, we recently achieved a significant victory in one of our cases when a federal district judge in the District of Columbia upheld the statute. And in fact, we're filing our brief today in the appeal in that case. Now, I mentioned that we're pursuing a multifaceted approach to ensuring access and guaranteeing non-discrimination. And Section 5 is obviously an important tool, but it's not the only tool. Among the new matters that we have prioritized its vigorous enforcement is the NVRA, the so-called motor voter law. Congress passed motor voter to establish procedures that will increase the number of eligible citizens who register to vote and to ensure accurate and current registration rolls in federal elections. Congress tasked DOJ with the critical responsibility of ensuring that this mandate is met. Now, this year, the department has brought its first 2 new lawsuits under Section 7 of the NVRA in 7 years. Section 7, as you may know, requires that voter registration opportunities be made available at, among other places, state offices providing public assistance or disability services. Congress specifically designed this provision to increase the registration of the poor and people with disabilities who do not have driver's licenses and therefore may not come in contact with other principal places where voter registration is made available. The first of our 2 Section 7 lawsuits was against Rhode Island, and we were able to reach a settlement in that case to expand these opportunities. And I'll tell you, we saw immediate results from the settlement. In the first full month after the agreement was filed, Rhode Island agencies covered by the agreement registered more voters than the state reported in the entire 2-year period covered by its last federally required report. In addition to Rhode Island, we have filed another lawsuit against Louisiana a few months back, and that litigation remains ongoing in Baton Rouge. Now, our NVRA efforts are not limited to Section 7. In the past 6 months, we filed 4 amicus briefs in district courts and federal courts of appeals on critical questions that arise under the NVRA, Section 6, Section 7, Section 8. One of these briefs was filed in connection with a lawsuit that challenged Arizona's proof of citizenship requirement to register to vote. We filed a brief before the Ninth Circuit in that case in which we argued that the NVRA already reflects Congress's judgment as to how registration forms should verify citizenship, and that further documentary requirements are preempted by the NVRA. So consistent with our dedication to using all the tools that are available, our work to promote greater compliance with the NVRA is not limited to litigation. Last year, for the first time ever, we published guidance on our website to provide a comprehensive roadmap for state and local officials, as well as the public, regarding NVRA compliance. We've heard a lot of positive feedback. We heard a number of suggestions about how the guidance could be improved, and in fact, we have done that. Now let me shift gears to our work enforcing voting rights for language minorities, which involves Section 203 of the Voting Rights Act and other provisions of the Voting Rights Act. These provisions provide critical protections to U.S. citizens who are eligible voters who may be limited English proficient. And we're working very aggressively to enforce those provisions. We worked closely with the Census Bureau regarding the new determinations under Section 203 of which jurisdictions are covered. And there are now more than 19 million voting age citizens from language minority groups that reside in covered jurisdictions. This compares with 13.4 million in the previous tally. So that's an increase of almost 43%. Congress has repeatedly found that language minorities continue to face significant voting discrimination, and our division is determined to ensure that language barriers do not restrict access to voting. So in this past year alone, we have brought lawsuits to resolve violations of language minority requirements to protect Spanish-speaking citizens in Cuyahoga County, Ohio, which is metropolitan Cleveland, Lorain County, Ohio, to protect Spanish-speaking voters there as well, and in Alameda County to protect Spanish-speaking and Chinese-speaking citizens. We have a number of other open investigations, and we expect to file additional lawsuits in the near future. And as I said, in these areas, our work is not simply limited to litigation. With the new determinations out there, we're working with jurisdictions to ensure that they understand the requirements and that we can prevent lawsuits from occurring by having the proper systems in place to begin with. Let me turn to Section 2, which is one of the linchpins of the Voting Rights Act. I've talked about access and ensuring non-discrimination, and let's talk about what we're doing in the Section 2 context. We've successfully resolved 2 Section 2 lawsuits in the past couple years. One was in Lake Park, Florida. The other was in Port Chester, New York. And in the last 6 weeks, we filed 2 statements of interest in connection with the Section 2 challenge to the Texas State, House, and Congressional redistricting plans. Again, our work in Section 5 is often leads to work in Section 2, and this is indeed an example of that. Now, Section 2 work, as you know, relies heavily on census data, and it's important to have census data that's current. And so a big part of our approach was to get the census data when it came out earlier this year and have a team of attorneys mining that data to determine where jurisdictions with Section 2 issues or potential Section 2 issues may exist. And so based on that data mining, we've opened more than 100 new Section 2 investigations in the past year. The total number of new investigations that we opened in the past year was the most ever. And so we'll continue to work on those cases. And some of those cases, again, arise out of our Section 5 function. Just because you have been pre-cleared under Section 5 doesn't mean that you get a seal of approval under Section 2. So we are working on a number of those cases. And one thing I've learned in this work is that it's important to look at the number of cases, but that is an incomplete measure of our success. Because a lot of times, our investigation catalyzes change. And let me give you one example. In one jurisdiction, we had a long-standing investigation. And the last stage of our investigation involves interviewing elected officials. And we do that when we begin to have confidence that we will indeed have a viable case. That's oftentimes one of the last steps in our process. And as they saw us approaching, and as a result of our conversations, the board's counsel advised us of their plans to adopt single-member districts to moot out our concerns about the dilutive effect of their at-large system. So I'd rather prevent a lawsuit by fixing a problem, and I was heartened that that problem was fixed and litigation costs were spared. Now, I spoke about our voter ID work and the critical issues involving voter ID and other registration procedures, and obviously Section 2 is another tool that is available for working on these issues. And so we've had a team of people, and we continue to have a team of people that are carefully reviewing laws that have been passed throughout the country through a Section 2 lens. And as you know, as we conduct that review, our work will be guided, as it always is, by existing precedent. And we will work, obviously, carefully, and we continue to look carefully at the Crawford case and its application to the work in the voter ID setting. One thing we've learned already is that every law in this context is different, and we will evaluate the facts under the legal standard in determining whether there is evidence of either discriminatory purpose or discriminatory effect. If there's one lesson I learned from the Crawford decision, the facts matter in reviewing all of these laws, and it's important to marshal facts before you can make a determination. Now, our commitment in this area of both Section 2, Section 5, all of the laws I described, is a commitment that I am so proud of in terms of the work, the leadership that's in place in the division. I have remarkable respect for our new section chief, Chris Herron. Many of you know him. He is a remarkably talented voting rights lawyer, and he has a team with him that is a team that has committed themselves to independent and fair-minded voting rights enforcement in all of these contexts. And we've also done a lot of work in enforcing the Uniform and Overseas Citizens Absentee Voting Act and the Military and Overseas Voters Empowerment Act. This law, the MOVE Act, was recently passed by Congress, and we were charged with enforcing it, and the 2010 cycle was the first cycle in which it was in effect. And during that cycle, we obtained court orders and court-approved consent decrees or out-of-court agreements in 14 jurisdictions to ensure that everybody had an opportunity to cast their ballot in a timely manner. And I'm proud of the work we did there, and we're continuing to work in that area as well. So in short, I hope you've seen that we're using every tool available to protect the fundamental right to vote. We have restored integrity and independence to our decision-making process. We've revamped our leadership structure so that we can effectively address the wide range of responsibilities in an environment where we are being asked to do more with less resources. Our voting practice is as busy as ever. In the last year, we resolved more matters by settlement or judgment than in any year in the past 14 years. We reviewed more than 4,500 submissions under Section 5, including 643 redistricting plans. We opened up 172 new investigations, which was more than any year that I am aware of. And already in fiscal year 2012, we have 9 new matters, and so I expect that we'll break the record that we set in fiscal year 11. We have come a long way in the process of restoration and transformation, thanks in large measure to the dedicated career staff. But we have a long way to go. Civil rights is about persistence. Civil rights is about making sure that we leave no stone unturned. We know that our authority and responsibility to enforce the Voting Rights Act and protect the right to vote is indeed a sacred trust. I've had a remarkable set of privileges in this job. I've had the opportunity to visit Greensboro when the museum opened and to meet with the living members of the Greensboro Four. 3 of the 4 are still alive. Had the opportunity to go to the Lorraine Motel and see the spot where Dr. King was shot. I've had the opportunity to travel to the Birmingham Civil Rights Museum, to the 16th Street Baptist Church, and to see how so many people did so much for this nation. I've had the opportunity to celebrate the 50th anniversary of the Freedom Riders in Jackson, Mississippi. And I point all this out, and I was so honored to be there with all the frontline foot soldiers and generals of the civil rights movement. And it was a motivating event for me, a motivating event for our staff, because it was a reminder of, indeed, the sacred trust that we have in guarding these crown jewels. And we will continue to do so. We will continue to enforce the law vigorously, independently, and even-handedly. I am so proud to work for an Attorney General whose constant admonition to me is follow the law and do the right thing. I am so proud to work for a president who has made civil rights enforcement, the restoration of even-handed civil rights enforcement, a top priority. And we will continue to implement that vision, and I am confident that the work we do ahead will be work that will expand access, ensure non-discrimination, and enable the American dream of opportunity to be a reality for all. So thank you for putting this conference on, Caroline. Thank you to all who've been in attendance. Thank you for your leadership. Thank you for your commitment. The marathon relay, which is civil rights, we have the privilege of holding the baton, and we take that privilege seriously. And I thank you for your commitment to the work of equal opportunity. Have a great day, and have a great conference.